Did you know that if you're not a U.S. citizen and you plead guilty to a crime, you can actually vacate the judgment if the judge or attorney did not let you know the immigration consequences? Please comment below. Let us know what you think. So we received an interesting inquiry here on our YouTube channel. Let's see here. Federico Morales asks us, 3 years ago, I was accused by my girlfriend of domestic violence. Years have passed and we started dating again. She accused me back then without having hit her. Now, we want to change the case from guilty to not guilty. She will say it was a lie that I hit her. Okay, well, first of all, actually, I'm going to say hi to Sarah Hamilton, who's watching us right now on our Facebook page. So here's the deal. I need to know, did you plead guilty to this offense, or were you found guilty by trial? I need to know where we're at in the case. Makes a huge difference. See, if you pled guilty to the offense, it's almost impossible to appeal your case. And the reason is because usually when you plead, when you fill out those forms where you enter a plea of guilty or no contest, part of the deal is that you're not going to try to appeal. So that's going to be a rough road. Now, if you were found guilty at a jury trial of that offense, you could do an appeal based on the fact that new evidence exists now that didn't exist at the time that you were found guilty by the jury. However, there's going to be another issue. Did your girlfriend lie to the police? Well, assuming that the girlfriend lied to the police, she could theoretically be charged with a misdemeanor for making a false report, which carries up to 6 months in the county jail. So she's going to be taking that risk. And, heaven forbid, when your case went to trial, if she lied in court. At that point, she would be charged with perjury, and she could be facing up to 3 years in state prison. So if she decides to say that she lied, she's going to be putting her head in a noose. You know, the other thing that you could do, and this is something that would help you pretty well, as long as you're a U.S. citizen, you could just do a record expungement. What you could do is under California Penal Code Section 1203.4, you can file a motion basically stating that you're rehabilitated, and the judge will want to look at your record, verify that you paid all your fines, did all your classes, did everything you were supposed to do. And if the judge finds that you've done everything that you were ordered to do, he can take your guilty plea and change it to a not guilty plea and have your case dismissed retroactively so that on paper it shows up that you're not guilty and that the charges are dismissed. That will help you for employment, housing, insurance, and so forth. Generally speaking, that should be good enough if you are a U.S. citizen. However, if you're not a U.S. citizen, that's probably not going to satisfy what you want. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, give us a call for free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.